overview of the most recent term, 5 cases, and then time for questions at the end. And so I would like to ask that all of you be thinking about some questions that you might want to ask, because we would really love to have some from the students particularly, and any other guests who are here today. So first we're going to start with the composition of the Supreme Court. There are 9 justices that serve, and I'm going to ask from the audience, starting with the person in the middle. Who was that? Person in the front middle. Don't be scared. Yes, Chief Justice John Roberts. Thank you very much. All right, to the left of him is who? Longest serving justice. From Georgia. That's Clarence Thomas. To the right of the Chief Justice is Samuel Alito. Far left is Sonia Sotomayor. Far right is Elena Kagan. In the back row, the tallest guy, that's Neil Gorsuch. To the right of him is Brett Kavanaugh. Far left is Amy Coney Barrett. And far right is Ketanji Brown Jackson. Now, in the last year, and so when we talk about a Supreme Court term, this OT 24 refers to October term 24. They start in October, and this year they ended in June. And 4,000 petitions were sent to the United States Supreme Court. But clearly we don't see here that they issued 4,000 opinions. They only issued 66 in this last year. And so this is a trend from the last 20 years, shows you how many in blue. Blue is where you're going to see the majority opinions issued by the court. And so there was an average in 1980 of about 160 a year opinions issued from the court. So we're looking at less than half of that in the last 20 years, basically. And particularly in the last 5 years, pretty much since COVID, there have been way fewer than there were in the last, the trend in the last 20 years. In the green bar is how many concurring opinions have been issued, and the yellow shows how many dissenting opinions. Of the 66 opinions that were issued last year, 42%, about 42% were unanimous. And the trend in the last 20 years has been about 44% in terms of unanimous cases. So you can see over the last 3 years, there's been a downward trend in unanimity. So here's some key findings, key facts from this last term. 42%, as I mentioned before, of the cases were unanimous. There were, of the 66 cases, of the 66 decisions that were issued, 56 were signed opinions and 10 were per curiam, which is just an unsigned opinion of the court. No one claims it. And then there were 110 emergency applications. Now that's unusual. That's quite high, and it reflects an increasing use of what is sometimes called the shadow docket for high-stakes disputes over presidential powers, immigration enforcement, and universal injunctions during the transition to Trump's second term. And so our first speaker is going to touch a bit on one of such decisions. Another notable fact from this last term is that just the Chief Justice, John Roberts, he is actually going into his 20th year as Chief Justice, which it seems like it was yesterday that he started for me. It's your whole life, sorry. And then, just like hit me, wow. Okay, and then also, he was in the majority 95% of the time. So he has, so what that means is like some, you see all these majority opinions, of those, he was in the majority 95% of the time. So I'm going to see what you know already, what you may have heard here, and what you may know about these cases we're about to address by doing a huge Kahoot. And there's a prize. So go ahead and get out your phones for me. And you're like, what are we doing? All right, game pin is coming up. 780-458, or the QR code's there too. Please put a clean name, please. And as you put your names on the board, here's a prize for the winner, which Susan Manro may appreciate is some of the things that I found in those two drawers. and somebody from Georgia College. All right, we've got 71 so far. This helps us to know how many people are here. It's respectable. All right, you have 10 seconds. We hit 90. All right, 100, 102. Okay, here we go. As you know, speed matters with these things. How many justices serve on the Supreme Court? Fingers crossed, you all get this right. Okay. Thank you to the 86 of you who knew this was 9. All right, we'll continue on. Here's our leaderboard. About how many cases did the Supreme Court decide in the October term of 2024? All right, I said it 3 times. It is 66, 56 signed opinions, and 10 per curiam. So between 50 and 75. This is always demoralizing if you just said these things. What is the name of the Chief Justice? Okay. That was John Roberts. How many years? 20, okay. Some people are listening. All right. Oh, that really mixed things up. We got Mary Elizabeth at the top. Natalie second. What did the Supreme Court address in Kennedy versus Braidwood Management? Right, that was fast. Okay. This is what our first speaker is going to be talking about. Next one. Oh, Natalie, you're on fire. What did the Supreme Court allow President Trump to do regarding independent agency officials? I appreciate your spirit. This is the Wilcox case, right? Oh, there was some change up. What controversial item is at the heart of Garland versus VanDerStok? Okay, ghost guns. Okay, if you're wondering what the pictures, they're specifically to get you in the wrong direction. So they have nothing to do with the words. They're trying to get you to pick the wrong answer. My apologies. Question number 7. What did the Supreme Court rule about federal courts' power to issue universal injunctions? All right, we have a lot to learn this evening. And the last question. Ty in the lead. Jacob's been on the board the whole time. Natalie, is that the same Natalie at number 3? Panda, top hat Natalie, I don't know which one it is. Last question. Free Speech Coalition versus Paxton challenges a Texas law regulating what type of content? And Roessing will understand why there's no picture on this one. Okay. Adult content on websites. All right, so let's see who's winning. So in 3rd place, Jacob, congratulations. Let's go slowly. Rachel in 2nd place, and please come to the front for your gift bag. Ty, come on. All right, as you come up, I want to introduce our first speaker because I know we all want to stay on time. Congratulations. All right, our first speaker is Randy Beck. He holds the Justice Thomas O. Marshall Chair of Constitutional Law at the University of Georgia School of Law. where he taught since 1997, and side note, I had him for property law when I was in law school. He previously served as Associate Dean for Academic Affairs and worked as a General Litigation Associate at Perkins Coie every year. How do you say it, Coie? Sorry. Coie in Seattle as an attorney advisor in the United States Department of Justice Office of Legal Counsel. He also clerked for the United States Supreme Court Justice Anthony M. Kennedy and Judge Patrick Higginbotham of the United States Court of Appeals for the Fifth Circuit, which happens to lead in petition volume and also has the most cases that were reviewed at 13 this year. His constitutional law scholarship focuses on separation of powers, Article III standing, and statutory interpretation. He will discuss Kennedy versus Braidwood Management and Trump versus Wilcox.
Good evening. You started at 12? Oh, okay. 1 minute for the clock.
Yes.
Okay. There we go. Perfect. All right, good evening. It's good to be back in Milledgeville again. Professor El-Jourbagy mentioned that she was a student in my class back in 2000. We have another GCSU student who's at the law school now, and so maybe I'll get a chance to teach some of you at some point. But, one of the most foundational constitutional questions is who decides? Right? We look to constitutional law to decide whether certain issues can be dealt with by the federal government or the state government, whether particular questions fall within the jurisdiction of the executive branch, the legislative branch, the judicial branch. And there's even a sense in which individual rights cases can be who decides questions. Who decides what you get to say? Is it you or the government, right? And so given the constitutional focus on who decides, there are some very important constitutional doctrines around who gets to decide who decides. Who gets to decide the people who will be holding decision-making power. And so tonight I want to talk to you about a couple of cases from last term, Kennedy versus Braidwood Management, which is about the appointments clause, the power to appoint government officials, and then Trump versus Wilcox, which is about the power to remove government officials. But these are really important cases right now because the Trump administration is moving aggressively to try and restructure the federal government. And so it's going to make a big difference how much leeway the court recognizes in the ability, particularly to remove government officials and replace them with new appointees. So the appointments clause is the clause of the Constitution, Article 2, Section 2, that was at issue in the Kennedy case. The appointments clause talks about people we call principal officers of the United States. And says if somebody is an officer of the United States, the way they get to hold office is the president has to nominate them, and then the Senate has to give its advice and consent, or we call that confirmation. So that's how the person becomes an appointee if they are a principal officer of the United States. On the other hand, there is a separate category called inferior officers, people with less authority. And in that case, Congress can decide on a less formal method of appointment. It can, by law, vest the appointment power in the president alone without the Senate, or in the courts of law, or in the heads of a department. And so in the Kennedy case, we're dealing with an entity called the U.S. Preventative Services Task Force. So let me kind of explain to you the important details of time when different things happen. So in 1984, this task force is created just as an advisory body within the Department of Health and Human Services. They're supposed to give advice about which preventative services in the medical field are particularly helpful, what kinds of screenings should be given routinely, and which ones are less helpful. 1999, Congress passes a statute codifying this agency, saying that this task force now is under the direction of the director of the Agency for Healthcare Research and Quality, and he has power to convene the task force. In 2010, the Affordable Care Act gets passed, what we call Obamacare. And that suddenly makes this task force very important. Because under Obamacare, anything they recommend as a preventative service has to be provided at no cost by health insurers to the insured. So now their decisions have big economic and legal consequences. Then in 2023, after the district court found that the appointment of these task force members violated the appointments clause, the Secretary of Health and Human Services purported to ratify and reappoint the task force members. And so the 6-3 majority opinion written by Justice Kavanaugh in the Kennedy case decided that as between principal officers and inferior officers, the task force members are inferior officers because they are they can be appointed by the Secretary of Health and Human Services, and they are under the Secretary's supervision. There's various ways of affecting the legal status of their recommendations. The point on which the majority and the dissent disagreed in the Kennedy case was not on whether they were principal or inferior officers, but whether Congress had, by law, given the power to appoint the task force members to the Secretary of Health and Human Services. The majority decided that it had done so through the combined effect of two different statutes. In one statute, Congress had kind of codified this task force in 1999 and said that this director of the Agency for Healthcare Research and Quality could convene the task force, and then in another statute, it had approved a reorganization of the department that transferred this director's functions to the Secretary of Health and Human Services. So the majority of the court says, if you look at these two statutes together, Congress by law has given the appointment power to the Secretary of Health and Human Services. That's okay for an inferior officer under the Appointments Clause. The dissenting opinion in the Kennedy case disagreed that Congress had by law vested the appointments power in the Secretary of Health and Human Services. The statute that the majority relied upon said that the director of this agency could convene the task force, but the dissent said that doesn't necessarily mean they could appoint the task force. And they also said, you have to kind of cobble together these two different statutes. There's not one place you can look and say, Congress said the head of this department can appoint the members of the task force. And so you should go back to the default in the Appointments Clause. They should be appointed by the President with the advice and consent of the Senate. Okay? Now, the second case that I want to talk about is about removal of government officials. This is Trump versus Wilcox. And Professor El-Jourbagy mentioned this thing called the emergency docket, that some cases come up on emergency motion. This is one of those cases. But the question is, who can remove an executive branch official or an agency official? And the court has said that there are two clauses of the Constitution relevant here. One is Article 2, Section 1, that says the executive power shall be vested in the President. And then later in Article 2, Section 3, it says the President shall take care that the laws be faithfully executed. So in 1926, in Myers versus the United States, the President tried to remove some postal officials. And the statute said that the President couldn't remove postal officials for any reason. They had to have particular causes for removal. The Supreme Court said, no, the President under the Constitution has the right to remove them because they're exercising executive power. And the executive power has been given to him. He's been told, you're supposed to make sure the executive power is faithfully executed. He can't do that unless he can remove people that he thinks are poorly executing the laws. But then in 1935, the Supreme Court came along and created a significant exception to Myers. It said that if you have an agency like the Federal Trade Commission that performs quasi-legislative functions like issuing rules or quasi-judicial functions like deciding cases, well then Congress can require cause for removal. They can require, in that case, something like inefficiency or neglect of duty or something like that. And so that allowed the rise of something called independent agencies, where we have agencies of the federal government that are exercising power and to some degree are doing so independently of the President. Now, in the Trump versus Wilcox decision, Trump purported to fire Win Wilcox of the National Labor Relations Board and Kathy Harris of the Merit Systems Protection Board, despite the fact that Congress had placed statutory limits on their removal. The firing of Wilcox was important particularly because it deprived the NLRB of a quorum, so that the NLRB could not issue any decisions until her seat was filled. The majority opinion in Trump versus Wilcox said that the removal of Wilcox and Harris would be effective while the litigation continued, right? So as long as we're trying to resolve whether they were properly fired, they cannot exercise the powers of their office. They said the government is likely to show that both these agencies exercise considerable executive power. But interestingly, the majority distinguished members of the Federal Reserve. The Federal Reserve is the bank that sets interest rate policy, and the court said the Federal Reserve is uniquely structured. It's a quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. The dissent by Justice Kagan thought that the majority was undermining a 90-year-old decision, Humphrey's executor, on the emergency docket without a good enough explanation for its decision. So this turns out to be a really significant case because of the controversy over the Federal Reserve. Why did the court bring up the Federal Reserve? Well, at the time, President Trump was making noises about firing Jerome Powell, the chairman of the Board of Governors of the Federal Reserve. And now the controversy has shifted to a different member of the Board of Governors, Lisa Cook. President Trump has purported to fire her, but the courts have allowed her to remain in place, even though she has supposedly been fired by the president. And so she was a participant in the decision last week that ended up lowering interest rates by 0.25%. Now, interesting facts, Lisa Cook grew up in Milledgeville. Professor El-Jourbagy tells me that she was actually the commencement speaker here last year. And so we are going to find out whether the Supreme Court thinks Humphrey's executor should be overruled, we should get rid of independent agencies. In fact, the court yesterday granted certiorari in a case that raises that question. And then we will also get to see whether the Federal Reserve really is different from other independent agencies so that you can still allow some independence from the executive branch for that particular role. So, happy to take questions later.
Let me get rid of that on the screen. Okay. So our next speaker this evening, this is yours, right? It is. Okay. The speaker of the presentation is Judge Alison Burleson. She serves on the she's a Superior Court judge with the Ocmulgee Judicial Circuit, which includes Baldwin County and 7 other counties. It's quite a large one. She drives around a lot. And she previously serves as an assistant district attorney in that circuit's district attorney's office and chief assistant solicitor general with the DeKalb County Solicitor General's office. She's a native of Tallahassee, Florida. She began her legal career as a prosecutor in DeKalb County and also taught as an adjunct professor at Georgia State. She brings extensive prosecutorial and judicial experience to the bench. Judge Burleson will discuss Garland versus VanDerStok. Judge Burleson.
Well, good evening. This is my okay. Just checking. All right, well, I'm glad to be here. I think that the last time I was here was about 10 years ago, maybe a little less. You guys were probably in 5th or 6th grade when I was here last. So let me just, I know that we have, it looks like, a large number of students. If you are a student and you're here, raise your hand if you're here because you are interested in the Constitution and learning about the recent Supreme Court cases. All right, raise your hand if you're here, either because you're required to be here for your class, or you're here under duress, if you're to meet smart chicks, I don't know. Raise your hand if you fall into kind of one of those categories. I thought so. All right, well, we just love audience. All right, and I know that at least those of you who are in Professor El-Jourbagy's class actually have a worksheet that you're filling out, right, where you're supposed to be listening for certain answers. I'm going to try to help you out. When we get to a part of the worksheet that I think is, if I remember correctly, something she wants you to note, I am going to try to give you a signal to get your pens out, okay? So what we're going to talk about very briefly in the next 10 minutes and 46 seconds is Bondi versus VanDerStok. I think in your handout it probably appears as Garland versus VanDerStok. That's because when it first started, a different attorney general and a different president. And so it started out under that name, but when the court actually issued its opinion, Pam Bondi was obviously the attorney general at that point, and so that's what the opinion's name is issued under. So let's get started. I want you to imagine a HelloFresh dinner kit, all right? You order it online, you order this dinner kit, It promises to deliver you a delicious dinner of creamy, sun-dried tomatoes, spinach, pasta, grilled chicken. Comes with all the parts or ingredients that you need. Comes with instructions on how to do it, and in about 30 minutes or less, with a little bit of kitchen know-how, some basic kitchen tools. At the end of this kit produces you a complete dinner kit. Got it? Okay. Now I want you to imagine you can do the same thing, but for a gun. And that's what we're going to be talking about in this case. I want you to imagine that you can go online, you can buy something that, in this particular picture, is called a buy, build, shoot kit. It arrives on your doorstep in parts. It is unassembled, but it has everything or nearly everything you need to make a fully functioning firearm. And with a little patience, maybe a little watch of a YouTube video, you can, in about 30 minutes, under an hour, have a fully functioning firearm with minimal skills, minimal tools, and you have that firearm without any trace. There's no serial number, there is no background check, and there's no accountability. That is what this case is seeking to regulate. This is what is commonly referred to as a ghost gun. The reason it is called a ghost gun is because it is untraceable. They lack serial numbers. And until recently, they really haven't been regulated. And so law enforcement isn't able to trace where they come from, who bought them, who put them together, who sold them. Now, initially, these ghost guns were popular with hobbyists, gun enthusiasts, people who enjoyed putting together these kits to make these homemade firearms. The problem, of course, is that they didn't just stay popular with hobbyists and gun enthusiasts. Can you think of anybody else who might find these interesting? Criminals! Yes, criminals. Obviously, people who either are prohibited by law from possessing firearms, minors, domestic abusers, convicted felons, or people who just want to be able to commit a crime without a trace. And so in about the mid-2010s, 2015, 2016, ATF and law enforcement started noticing these ghost guns were turning up in crimes around the country. And it was becoming somewhat of a problem. In 2016, I think they had about 1,600 guns submitted for ATF trace. And then in 2021, that number had jumped up to about 20,000. All right. I will tell you that ATF in California estimates that about a third of all the guns that they pick up in crimes in California are ghost guns. And they have seized approximately 72,000 ghost guns that ATF knows about across the nation in the last few years. So this is what we're talking about when we're talking about ghost guns. These are seized ghost guns. So these weapons, of course, because they're untraceable, have been used in crimes. They've been linked to mass shootings, school shootings, gang activity, and it became eventually what the ATF said was a public safety crisis. And so now that you kind of have this foundation, how does this issue get into the court system? How do we end up with where we are here for the case we're going to talk about for the next few minutes? Well, you kind of have to understand a little background of the history of our country. In the 60s, when RFK and Martin Luther King Jr. were both assassinated, it was an event that stunned the nation. And it sort of initiated this push for gun control because people felt like, and Congress felt like, guns were too readily accessible and not traceable enough. Thus, they passed the Gun Control Act of 1968. And in that act, it set certain provisions that manufacturers of guns and sellers of guns have to follow. You've all heard of them. The manufacturers have to have serial numbers stamped on guns and gun parts, and people who sell guns have to do background checks and have to keep records of who they sell to and what those serial numbers are and who bought what gun and what that matches to. The idea is that we think it's important, and the government thinks it's important, to know who's buying firearms, to keep them out of the hands of people who they don't belong to. If that's for me, just take a message. And also to keep people track of who purchases a particular firearm. Do we know which one that is? Sorry, I can't hear the particular universe of people who have these guns, because ghost guns, as you heard, bypass all of that, okay? So when we get to this public safety crisis in 2022, President Biden, our then president, says, ATF, get on it. He tells the Bureau of Alcohol, Tobacco, and Firearms and Explosives, they're the federal agency that regulates firearms, he tells them to get on it. You need to do something about this. And so ATF looks at what constitutes a firearm with the Gun Control Act, which the definition is here for you. A weapon that is designed may readily be converted to expel a projectile by action of an explosive or the frame or receiver of that weapon. They look at that and they think, how can we regulate ghost guns? So they issue a final rule where they sort of reinterpret or clarify what qualifies as that. And in that, they say that, hey guys, weapons parts kits that can be readily converted qualify as a firearm that has to follow the rules with manufacturer serial numbers and background checks. And also frames or receivers, even if they're partially assembled, if they can be readily completed to function as that, then they qualify. Okay. Well, knowing that, how do we get to here? Well, before this new rule that ATF came up with could go into effect, a group of gun owners and gun rights activists in Texas went to district court and said, no, you've overreached, and they actually sued in federal court to keep this rule from going into place. So this is what we call sort of a pre-enforcement challenge. They weren't challenging, this isn't a situation where someone got arrested with a ghost gun or selling a ghost gun and they're testing a particular weapon or kit. They're saying across the board, we're facially challenging this rule. We think it's inconsistent with the Gun Control Act, and you guys overstepped. They filed suit in Texas, and Texas District Court agreed. That got appealed by the government to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals affirmed mostly. And so that brings us to the Supreme Court with what eventually became Bondi versus VanDerStok. ATF said, guys, we haven't changed anything. This is how we've been interpreting the rule for 50 years. Look at our letters, look at our history. We've always looked at how long it took to make a weapon fully functional, even if it's not fully assembled. That's nothing new. And by the way, you guys are advertising these things as ridiculously easy to assemble. Idiot-proof, fully functioning firearm in 15 minutes. You are the ones that are wrong, manufacturers of weapons parts kits. You're the ones who are trying to circumvent basic requirements under the Gun Control Act. Well, the other side said, no, parts is parts. A kit or a package of parts is not a weapon or a firearm under the Gun Control Act. It's much more complicated to put these things together than you say. It requires special assembly tools, skill, specialized tools to make it into a firearm. And by the way, you're not just clarifying a rule, you guys are trying to rewrite the law and create a new law, and that's not your function as an executive branch agency. You're the legislator, or that's a legislative branch function. So, okay, what did the court say? Well, the court ultimately sided with ATF. They reversed the Fifth Circuit in a 7-2 opinion authored by Gorsuch. They held that the Gun Control Act does, in fact, allow ATF to regulate weapons parts kits. They say, first, there's got to be a weapon, of course, and that has to be able to expel the projectile. Remember the definition I gave you. And that at least some weapons parts kits are going to qualify for these requirements. And they kind of focus, Justice Gorsuch kind of focuses, in his opinion, on a particular kit that's sort of submitted by the ATF for them to look at. And he sort of comes back, and I'm going to show you a picture in just a moment, and says, really, the kit's name says it all. Buy, build, shoot. And what happens is they actually put a picture of the buy, build, shoot kit before, as you receive it in the mail, in the opinion as an exhibit, and the finished product. Is there any doubt in anybody's mind that that is a firearm, is essentially what the court says. They also say this allows the ATF to regulate frames or receivers. That's sort of the housing that holds the firing mechanism and that the barrel attaches to, even if it's partially completed, and gives an example of that. I'll just leave you with this thought. Obviously, the court only decided this sort of broadly, that the act does not preclude the ATF from promulgating this rule, but they left open the possibility that there may be some weapons parts kits that don't meet this definition. So something for you all to think about is, what does this mean for the future of firearms commerce? Is this going to force people out of business because it's so heavily regulated? Is this going to force the creators of this kits to be more clever, make these things a little more challenging so they can thread the needle between what's readily convertible and what's not? I think this is an important case to think about what happens when technology starts to kind of maybe outpace the law a little bit, like we've seen with cell phones and electronic data and things like that. Of course, gun rights folks are concerned about what this means for the Second Amendment. Do I have a right to keep and bear arms, and does that translate to me getting to manufacture an untraceable firearm in my garage? So that's Bondi versus VanDerStok.
Thank you, Judge Burleson. Our next speaker this evening is Diallo. She's a clinical assistant professor at Georgia State University. She previously practiced as a litigation attorney and mediator with experience in family law, personal injury, workers' compensation, insurance defense, and business law. Ivy earned her JD, MBA, and BA in Spanish from Georgia State University and began her legal career representing domestic violence victims while still in law school. She also served as a commencement speaker there, as I recall. I believe I saw you on a video. It's very inspiring. She continues to work as a business consultant and brings her diverse legal practice experience to the classroom. She's going to discuss Trump versus CASA.
Hello. Hello. Hi. I need more energy because let me just tell you that you are my test subjects on my first Prezi, okay? Every time I change frames on this Prezi, I need y'all to be like, ooh, ah, okay? Now, if I mess up, just be quiet. And I'm actually, Are we there? All right, we're there. Ooh, thank you. So I'm gonna be kind of interchanging between two types of technology. I really spread my wings for y'all today. Okay, I don't even do this for my classes, okay? So I'm gonna be talking about, obviously, Trump versus CASA Inc., et al. If you don't know, et al. Means and others. So it's not just CASA Inc. who's involved in this case. There's various individuals, organizations, and also states who are involved in this case. And it's pretty recent, obviously, June 27, 2025. You ready? Okay, it's not working. Ooh, thank you very much. So I am not, real big on the news, but I wanted to kind of see, like, if I just Google Trump versus CASA images, what would come up, right? And so here's some of the images that came up. And so I want you to just take a look at, this is literally what I put in the Google search. I did a screenshot of the screen of what came up. And while you take a look at that, I want you to scan this QR code. Hopefully it's not too large for it to work, because I want to get a little bit of feedback from you on what you think this case is about. Can you see the passcode, or is it too low? Is it too low? Okay, wait a minute, hold on. It's Q4EOFL. Q4EOFL. Okay, let me see. Are you in? Are you in? Okay, so here's the first question. I want you to choose a statement that most closely describes your current knowledge about this case, okay? I haven't really heard anything about it, but I think it's about birthright citizenship, okay? Or, I haven't really heard anything about it, but, or the first one is, I haven't heard, well, listen, I messed up because I put them both the same. The first one is supposed to be, I haven't really heard anything about it, but I think it's about birthright citizenship. The second is supposed to be, I have heard about it, and it's about birthright citizenship. The third one is supposed to be, I haven't heard much about it, but I think it's about balance of powers. And the last one should be, I have already heard of this case, and based on what I know I've heard, the legal issue is about balance of powers. So I wanted to see what you all kind of think. Okay, all right. Looks like for the most part, most people either have or haven't heard it, but they think it's about birthright citizenship. Okay, great, thank you. Let's go back to my fantastic president. Ooh. Thank you very much. Okay, so what is this case about? What is this case about? This case stems from Executive Order 1416. I heard the clicking of the pens. They were like, this is something I need to know. Executive Order 14160, which President Trump signed into place January 20th, 2025. It was one of his day one executive orders. Hello? Thank you. Okay, it's titled Protecting the Meaning and Value of American Citizenship. So this executive order is talking about what makes an American citizen, essentially, but specifically, it's talking about whether a person will be recognized as a U.S. citizen if their mother is not lawfully present in the United States and their father is not either a citizen or a legal resident. The answer would be no. Under this executive order, they would not be recognized as an American citizen. And the other situation would be even if the mother is legally in the United States when she gives birth, but she's not permanently here. She's just here temporarily. And the father is not a citizen or legal resident. That person also born in the United States would not be recognized as an American citizen. Okay, so this is what we call birthright citizenship, okay? I want to give you just a little bit of historical background on why this even matters. Okay, so back 1856, the Dred Scott case involved an African-American slave who was filing suit, essentially saying his constitutional rights were being violated. In the Dred Scott decision, the Supreme Court said, well, because you are an African descendant, you aren't recognized as an American citizen, even though you were born here in the United States. So, in response to that Supreme Court case, years later, 1868, the Congress enacted the 14th Amendment to the Constitution, which says, I'm not hearing any oohs and ahs, and I just feel like, this is nice. This is pretty seamless so far. All right, which enacted the 14th Amendment, which says all persons born and naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States, okay, and of the state where they reside. So, this executive order saying, well, even if you're born in the United States, but, there's these limitations that you're not going to be an American citizen, has been a little worrisome and problematic. So, let's talk about the procedural history of how this case came to the Supreme Court. Thank you. There were lawsuits filed in Washington, Maryland, Massachusetts, in the district court. Whoa. Not yet. No, that's not right. Hold on. Sorry. so excited. Okay, these cases were filed in the district courts by individuals, organizations, like nonprofits, right, who are concerned with kind of justice issues, and states all filed lawsuits seeking to enjoin, which means to stop, the executive branch, the president, from enforcing this order that denied people citizenship. And so in those cases, the district court judges found that, this was unconstitutional, you can't do this, and so we're going to issue a universal injunction. And so what's a universal injunction? Don't worry. Thank you. A universal injunction is a court order that says, no government entity, you can't do this thing that you're trying to do, in this case, because it's unconstitutional. And not only can you not do it in this case, but you can't do it regarding anyone, anywhere in the United States, right? And so those district court decisions were appealed by the president, the executive branch, and the courts of appeals in those three cases all agreed that they were not going to stay the injunction, which means they were not going to put it on hold. They were not going to say that they weren't valid, that they upheld those district court decisions. Okay, so of course, it gets appealed again on an emergency basis to the Supreme Court, and that's where we're talking about Trump versus CASA. So, what the president was asking the Supreme Court to do was to issue a stay on the lower court's order. So that means basically kind of like, we're not gonna recognize the lower court's orders, except as they apply to the actual people that filed the cases, okay? While we're waiting for these appeals. Okay, so now that you know this additional information, I want you to go back to go back to the slide. Let me see if I can make it work. And I want you to now answer this question. Now, which of the following is most closely related to the legal issue in Trump versus CASA, before I actually give you the issue? Look at that. All right. So why did I do this exercise with you? It's because oftentimes we hear about cases in the news, we see things on social media, TikTok, whatever, and it's not really what the case is about, right? So in this situation, yes, the underlying substantive issues are about birthright citizenship in this case. However, the decision that the Supreme Court was deciding was specifically about the power of the district court to issue an injunction, essentially stopping the enforcement of an executive order anywhere in the United States as it applies to anyone, okay? So that's what the issue is. Boom. Talked about universal injunction. Now, universal injunctions are not like a new thing, okay? Universal injunctions have become more popular, and especially popular with this administration, because there's a lot of changes that are trying to be made. And so with that, there are a lot of people trying to stop those changes for one reason or another. And so the Supreme Court essentially said, yeah, this isn't new, but this is something that we're gonna deal with. We're gonna put this to bed because it's becoming more and more popular that these universal injunctions are happening. Okay, so in this case, for the arguments, President Trump essentially said that a federal district court judge shouldn't have authority to make a decision that binds the president for, jurisdictions. Oh my gosh, that was a little alarming. I'm sorry, I'm not really almost done. I'm just doing overtime. That they shouldn't be able to bind the president, the executive branch, as to jurisdictions outside of their own, because that's outside of their authority. That they only should be able to bind these individuals involved in this case, in this jurisdiction. And also that historically, this nationwide injunction, universal injunction thing, yes, it's been rising in the recent history, but like, this is not really a thing. And the opposing arguments were essentially that, yeah, but we know this is unconstitutional. Like, we have Supreme Court cases that say you actually can't not recognize a person who's born in the United States as a citizen. We've already decided this is old news. So they can't override that. Ultimately, the Supreme Court looked at really the history of the law. They looked at the Judiciary Act of 1789 that says federal courts have jurisdiction over suits in equity. What's equity? Essentially, equity is a fairness, right? I'm not asking the court to give me money. I'm asking the court to either stop someone from doing something or make them do something because it's only fair that they either stop something or do something. Let me go back. Only those kinds of equitable remedies that were traditionally accorded by courts of equity back in the country's inception, like back when we were forming the United States from England, right? So the court looked way back then. They said historically, the general rule was that cases in equity could only apply to those people who were materially interested in the suit. That means the people who are named in the suit, not everyone everywhere. And they also looked at previous Supreme Court decision that said that neither declaratory nor injunctive relief can interfere with enforcement of a statute or ordinance except as to particular plaintiffs. So you can't stop enforcement of some legal act or some legislative action or executive action only to those who are involved in the case. Ultimately, the holding in the case was that the federal district courts did not have authority to issue those injunctions stopping enforcement of those orders to anyone other than those who were named in the suit. So the Supreme Court agreed with President Trump's arguments about the history of the law, and that was outside of their authority. But this is really kind of a temporary decision because we don't know the answer to the question still about birthright citizenship. This did end up being a 6-3 decision. Justin Kagan, Justin Jackson, Justice Sotomayor, all dissented. And their arguments were essentially like, it's not really fair if somebody's doing something if the president is doing something that's unconstitutional, that we just let him keep doing it, right? We should be able to stop him from doing it. The rest of the justices, in one way or another, said, yeah, but this isn't the way to do it. They're going to have to either bring a class action lawsuit, they're going to have to bring some other legal action to stop this enforcement of this executive order. But for now, we're only going to stop it as to these people.
All right, our final speaker of this evening, you're not going to want to miss, because it's an interesting topic, a little bit of a risk to throw this in here, but we have Matt Roessing, who teaches legal research and writing in Emory Law School. He previously taught business law at the University of Georgia and Georgia College State University Business Schools. He began his legal career in Washington, D.C., representing companies in civil litigation and international trade matters. He continues to practice law here in Milledgeville with a focus on business and real estate. He's going to discuss Free Speech Coalition versus Paxton, where the Supreme Court upheld a Texas law requiring pornographic websites to use age verification. Matt Roessing. Please don't embarrass me.
Don't mind me, I'm just here to fix the washing machine. Well, so what do you think this is? Yeah, in the back? Hey, Jay, can we get a microphone back here? No. That's right. We're going to have plenty of opportunities for audience input, so don't worry about this. All right, so show of hands. It's okay. It's okay. We're serious academics up here, so we don't need anecdotal evidence. We're just going to look at the research, right? So what does the research say about this? Wow. In a 2018 U.S. study, 91.5% of men and 60.2% of women said they had recently viewed pornography, and the rest of them lied. I'm joking about that. But young people are more likely to have viewed pornography than others. So, statistically speaking, it's very likely there's just like one guy in this room who does not watch porn. So it's okay. It's okay. Gotcha. Stand strong. Because they don't need your money. In 2023, the top 3 porn sites got more monthly visitors than Amazon, TikTok, and Netflix. The top websites are porn sites in America. And sex sells, especially online. Porn industry, we don't have precise numbers, but it's estimated in the tens of millions of dollars, maybe upwards of billions per year, maybe upwards of 100 billion. And this is comparable to the NFL, pro sports, and Hollywood movies. But despite the mass appeal of pornography, throughout U.S. history, the government has tried to restrict it, often state governments trying to restrict access. And that raises this question, is there a constitutional right to porn? So, the Constitution does not say porn, but it does say freedom of speech shall not be abridged. And the Supreme Court has interpreted that to mean that both the ability to provide a message and the ability to receive a message is protected by the Constitution, unless one of these very limited exceptions applies. Now, as you might guess, when it comes to pornography, the likely exception is obscenity. So the question becomes, is pornography obscene? How do you determine what is obscene? What does that mean? If you're an early American judge and you're struggling with this, there isn't much to go on. In fact, what you usually go on is what was said by the English judges in the 1800s, what we call English common law. So this is an early American judge. His name is Judge Learned Hand, and that is his actual name. He's very famous among lawyers. He never made it to the Supreme Court. He was a very respected New York judge in the early 1900s. He's had a huge influence on American law. So when Judge Learned Hand was supposed to figure out if a certain book was obscene or not, he said, I know what to do. I'm just going to look at the test that was laid down by English Judge Lord Cockburn, and that is his name. So Lord Cockburn, when one of the fun things about legal research is that I'll be looking at these cases and going down the rabbit hole, and I'm reading U.S. v. Kennerly, and then I see a little gem like this. And now I have to know. I have to know what this English judge was up to. So, here we go. A little history lesson for you. This is Lord Cockburn, the chief judge of the English courts in the mid-1800s, Chief Justice of England. And he developed a test for obscenity, called the Hinckley test. Now, for him, it was about keeping material out of the hands of those most likely to abuse it. So it was a pretty strict standard. You can't have this stuff out there where somebody who's susceptible to it might get corrupted, even if we're not worried that normal people might get corrupted by this material. Now, ironically, some people actually accused him of being one of those people that needed this enhanced protection. So Queen Victoria once refused to give him a noble title due to his supposedly loose morals. And this line from his memoirs probably didn't help matters. So, back to Judge Learned Hand. Okay, what is obscene? He actually decides to change that English common law test a little bit. He thought the law should be more concerned about the potential of corruption to the average person, rather than people that are already susceptible to this. So he said, to put thought in leash to the average conscience of the time is perhaps tolerable, but to fetter it by the necessities of the lowest and least capable seems a fatal policy. I know, kinky. So, another view on this is Justice Potter Stewart. This is a very famous line that everybody knows. He had a very honest and vague definition of obscenity. He said, I know it when I see it. He thought the only thing that should be obscene is hardcore pornography, but he really struggled to define what that was. He said, I know when I see it. And in fact, if there is a main theme to the Supreme Court's obscenity jurisdiction, I think he nailed it. I think he did a good job. They've never decided They then decided on the precise definition of what obscenity is. So in this case, Jacobellis versus Ohio, a majority of the Supreme Court agreed that a certain film was not obscene, but they couldn't agree as to why, and therefore they really weren't providing any guidance to lower courts for the future. And to make things even worse, the one thing they did agree on in this case is that whether or not a particular thing was obscene had to be decided by judges. It could not be decided by juries. It was a constitutional question. So that means only the Supreme Court can make the final call on whether a particular thing is obscene, and they only know it when they see it. You see where we're going with this? Thus begins the adventures of the U.S. Supreme Court porn inspectors. This was the 60s and 70s of the U.S. Supreme Court. And this is the 1970 Supreme Court going to watch some porn. Or maybe they're coming back from watching some porn. I don't know. They watched a lot of porn. And we know this because it was in a book written by Bob Woodward, a famous journalist. It's called The Brethren. And in this book, he talks about how the Supreme Court would have movie nights. And they would make some popcorn, and the justices and their clerks would sit down, they would watch pornographic movies. They would look at all the banned movies that they were supposed to be deciding if they were obscene or not. And they would talk about it, and they'd make the decision. So one of the things that might make a movie not obscene, even if it had sex in it, was that if it was educational. So some pornographic videos would try and get around this by calling themselves documentaries. And the sex scenes would periodically be interrupted by narrators who would try and establish an educational context, kind of like David Attenborough narrating over the action. Justice Thurgood Marshall, who was fairly new on the court, he was known to be a little bit of a jokester. So after he watched one of these educational movies, he turned to Justice Blackmun. He said, "Well, Harry, I didn't learn anything, did you?" But this is an educational event. And, Jehan, she's very nervous, but the U.S. Supreme Court, they made it through their porn era without too much moral damage. And therefore, I think we're going to be fine. Because you guys have been so good, this whole time, I'm going to let you watch one porn, okay? Just a short one, okay? So let's see. Where'd the porn go? Okay, so 91.5% of the guys were not surprised by this. You know about this. What has happened is Georgia required porn sites to have age verification, meaning you have to show government ID before you log on to a porn site, like Pornhub, again, the very famous, the #1 porn site, or was, in America. So some of these major porn sites have decided that rather than doing that, they're simply not going to allow viewing from this state. And this very nice, fully clothed person will tell you about how you should contact your elected official if you want to watch some porn in Georgia. And this is all due to this case. Free Speech Coalition versus Paxton. Now you can take the notes. So 2023 Texas law requires age verification for pornographic websites. And then 21 other states get in on it too, including Georgia adopting similar laws. The porn industry sues, saying this law infringes on free speech rights. People trying to access pornography. All right, the current Supreme Court test is called the Miller test. And wink, wink, this is one of your key points. The average person applying contemporary community standards would find the work as a whole appeals to the prurient interest. What does that mean? It kind of means like seedy sexual activity. It's almost making a judgment call that it's not healthy, sexual activity, but unhealthy in some way. And then again, it depicts or describes in a patently offensive way sexual conduct and has no serious literary, artistic, political, or scientific value. Now, back in the 60s, there was at least a number of Supreme Court judges that found that hardcore pornography, whatever that was, met a test like this. Nowadays, it's generally accepted among the Supreme Court that pornography of most types does not meet this test. It's almost impossible to meet this test, according to the Supreme Court, to be devoid of all value. So most pornography under the Miller test nowadays is going to be seen as protected. But in a later case, a case that was a bit earlier, the Supreme Court had said that If you're restricting minors from seeing it, then you can apply the test as it relates to minors. And therefore, something that might not be obscene to an adult could be obscene to a minor. In fact, pretty much all pornography is seen as obscene to minors. And here we get into the weeds of some constitutional jurisprudence called levels of scrutiny. So in figuring out how to deal with a state law that infringes on fundamental liberties, the Supreme Court established these levels of scrutiny. And normally, if you are infringing on the First Amendment or the Second Amendment or any fundamental right, that law gets strict scrutiny by the Supreme Court. They're going to look at what Texas is doing very carefully. And they're going to say, Texas, you got to prove that your law is narrowly tailored to achieve a compelling state interest using the least restrictive means possible. You have a very good reason for this age to prevent minors from getting pornography. And this is the only way you can do it. That's what strict scrutiny would require. However, if it's not a fundamental right, it just gets this test we call rational basis review, which just means your law has to kind of relate to a legitimate interest. And the state almost always wins. However, the Supreme Court, really in the 60s, but sporadically, has started to say there's an intermediate level of scrutiny. Laws that discriminate based on gender or parentage are the traditional ones that got this intermediate scrutiny. But the Supreme Court has also said laws that incidentally infringe on your rights can meet this test. Incidentally, whatever that means. And if it's an intermediate scrutiny issue, it has to be substantially related to an important state interest. The major difference with strict scrutiny is there could be other ways of doing it. And the government just chose this one. That's okay. All right, majority opinion. 6-3. What do these folks have in common? Conservatives. They were all appointed by Republican presidents, and they were the ones in the majority. And here is their reasoning. They kind of make some common sense. They say pornography is obscene to minors, but not adults. Okay, everyone pretty much agrees on that. Age verification is an appropriate, necessary way to restrict access to minors. We already do it with booze and alcohol and firearms, cars. And age verification has always been common if you wanted to buy a pornographic magazine. So what's the big deal? Now here's where it gets a little controversial. They say adults have a constitutional right to access porn, that's true, but they don't have a constitutional right to avoid age verification. And therefore, by making you all show your ID before you log into a porn site, we are only incidentally burdening your constitutional rights. That was their theory. And therefore, intermediate scrutiny applies, and they thought this was fine under intermediate scrutiny. Now, these three women are the liberal wing of the court, appointed by Democratic presidents. Kagan, joined by Sotomayor and Jackson. Kagan wrote the opinion. And her big problem was that the court should have used strict scrutiny, is what she said. None of this intermediate scrutiny. And this was her theory. This law, this Texas law, covers speech that is constitutionally protected for adults, true. It impedes their ability to view that speech, true. And it imposes that burden based on the speech's content. Case closed. This is how we've always used strict scrutiny. And she says maybe this law still works. We're not saying it would lose. We're just saying put it under strict scrutiny. And if Texas can prove this is the only way to prevent minors from getting online porn, then they'll win anyway. But she was in the dissent on that. And therefore 21 states have now imposed these standards. Thank you.
All of our speakers. Now we have some time for some questions, and I'm going to take my mic to the audience, and then we have mics on the stage for the speakers. So will you please raise your hand if you have a question? Please raise your hand if you have a question for one of our
I either
speakers.
purposely didn't give you the answers that you needed to force you to ask questions, or I just forgot to say it because I ran out of time. I'll let you decide.
This is for Ms. Paxton.
Oh, okay.
Yeah, so it's about the Bondi case. Will the case have an effect on like 3D printed loads and stuff like that, such as the ones that were used in the United Healthcare shooting of the CEO? And like regulating, will it have like issues regarding that in the future?
That's a good That is a good question, because obviously 3D printed guns are just as anonymous and untraceable as ghost guns. You know, they don't really talk about that much in this opinion. What I kind of wonder is back to that question, food for thought we ended on, about how is this going to affect firearms commerce and what the universe of firearms looks like. I kind of wonder if weapons parts kits get to the point where they are completely outlawed. And by the way, I will just tell you, the ATF says that even in the 2 or 3 years that they've regulated ghost guns, the rule has had its intended effect. It has significantly decreased the sale of weapons parts kits, because now that people have to put serial numbers and background checks and accountability and traceability into effect, they're just not attractive to the people who want them for nefarious reasons. I say all that to say this, to your question, is I kind of wonder if what's going to happen is, in addition to weapons parts kits getting more creative to sort of thwart this rule, if that's not going to cause a rise in the 3D sort of gun parts kits, where you aren't buying a weapons parts kit, you're not buying something that could even reasonably be argued to be a firearm. You're buying raw materials, you're getting plans off the internet, and you're making that in your garage yourself. So I guess the answer to your question is, I don't know. I think it has the potential to sort of increase that issue or problem. And so it'll be interesting to see how ATF sort of tries to regulate that, or regulate people who sell those materials or those plans. I'm going to defer to our constitutional scholar here. I think there was a case a few years ago that was like, and there's sort of this offshoot with the 3D guns of the plans being published online, and whether I have a First Amendment right to publish for free online plans to make a 3D printed gun. Honestly, don't remember what the court decided on that. I'm going to have to refer to you on that.
They talked about whether you could post online or publish like instructions for making nuclear weapons. I remember that was an issue, but I don't remember thinking about it.
Okay, and maybe that's what I'm remembering, but I sort of wonder if that's where we may be headed on that issue, because I think it's going to potentially cause an increase in those types of homemade weapons.
We have time for, I'm sorry.
I was just going to say, the case you're referencing, it was during the Obama administration, and the Obama administration didn't think they could actually stop that. They were worried it was a First Amendment issue. So what they actually did is they did it on international trade grounds. The theory was that this information was being promulgated not just the U.S., but to other countries as well. So they stopped it under export control laws, and I believe that was upheld. So it was kind of a clever way of getting around the First Amendment.
Very smart.
All right, we have time for about 1 or maybe 2 questions. Another question from the audience?
Somebody must have a question about your worksheet.
I would think, I would think, unless they just.
Oh, I see one here.
I'm sorry, what was your name?
My name?
Yeah, that's all.
Oh, my name is Diallo. Is that all? That's all. Really?
Any other questions? Well, let's please give our guests who came quite some way a round of applause.